Judge.
You want to do it right here? All right. Anyone that's going to testify, if you'll raise your right hand, please.
You solemnly swear or affirm the testimony you're giving today is true and correct, so help you God.
Yes.
Okay, you can put your hand down. Let's start with number 72, the state of Timothy Michael Bennett. Judge, you're up.
All right, Miss Bennett, if you can unmute yourself.
Okay. Can you hear
There
me?
we go.
Okay. Sorry about that.
All right. May I proceed, Judge?
You may proceed.
All right, thank you, Judge. Miss Bennett, can you go ahead and state your name for the court?
Christy Bennett.
And Miss Bennett, is it correct that the decedent Timothy Michael Bennett was your father? Is that right?
Yes, sir.
And is it correct that your father passed away on or about June 19th, 2025 at Baytown, Harris County, Texas?
Yes, sir.
And is it correct at that time he was 68 years old and he was residing in Baytown, Chambers County, Texas at the time of his passing? Is that correct?
Yes. Yeah.
Okay. Miss Bennett, we filed an original will with the court dated June 2nd, 2025. You filed that will yourself, correct?
Yes, sir.
Judge, we would ask you take judicial notice of the original will on file with the court. Miss Bennett, to your knowledge, the original will we filed with the court, is that the last will and testament of your father?
Yes, sir.
And to your knowledge, did he ever revoke this will?
No.
Were any children born or adopted by your father after the date he executed this will?
No, sir.
At the time he executed the will, was your father of sound mind and at least 18 years of age?
Yes, sir.
Did your father ever get divorced after the date of this will?
No.
Has there been more than 4 years since the time your father passed and the date we filed the application to probate the will?
No, sir.
Is the state of Texas or any charity a beneficiary under your father's will?
No.
And at the time of your father's passing, did your father own property valued in excess of $50,000 in Chambers County, Texas?
Yes.
Did your father ever apply or receive any Medicaid benefits on or after March 1st, 2005?
No, sir.
And is there a necessity for an administration of his estate?
No.
And are there any debts owed by your father's estate?
No.
Judge, I have no further questions. We ask that the will be admitted into probate and that the affidavit of fulfillment of terms be waived.
So done. Admit the will to probate is minimum item. Thank you, Counselor. Judge.
Thank you, Judge. May we be excused.
You may be. Have a good day.
You too.
Thank you.
All right, Mr. Baker, we're going to go to you, get you out of there so they
All right, thank you. Are we ready?
have executive session. All right, cause number 79, state of Jesse Romaine Sherman. You may proceed, Counselor.
Thank you. Judge, this is an application for probate of will as a muniment of title. And I have here Martha Linnell Sherman, who was the wife and surviving spouse.
Morning, Martha.
Hey.
And now, Martha, you were married to Chipper, and Chipper's real name was Jesse Romaine Sherman II, correct?
Yes, sir.
But we'll call him Chipper.
We'll call him Chip.
And we're here to ask the judge to admit his will to probate as a muniment of title.
Yes, sir.
And, you know, I'm showing you what we gave the original to the judge, and that purports to be Chipper's last will and testament. Is that true?
Yes, sir.
And it's a self-proving will. It's got witnesses and with the affidavit on it. And now, after the date of this will, will was dated November 9th of 2015. After the date of that will, did Chipper have any children?
No.
No. And if Chipper had revoked this will or done a new will, would you have known about it?
Yes, sir.
And so he did. This is his last will. Okay.
Yes, sir.
And now, Chipper was born in Beaumont, 24 May 1948, and died October 21st of 2024 in Chambers County, Texas,
Yes.
right? And this was the only marriage for either of them.
Yes, sir.
And so his death terminated your marriage.
Yes, sir.
All right. Now, at the time he died, y'all lived there on Sherman, called it Sherman Wood Road, right? Wasn't it?
Sherman Woods
241 Sherman Woods Drive, Wallsville, Texas.
Yes, sir.
Okay. And Chipper was, how old was he when he died? 76. Yeah, 76 years old. Okay. And as the will shows, the state of Texas and a charity, and there's no beneficiary other than you, correct?
That's correct.
And Chipper did not apply for or receive Medicaid on or after March 1st of 2005. Is that correct?
Yes, sir.
Yeah, that's correct. Now, I've shown you this document entitled Proof of Death and Other Facts. You've read this,
Yes.
right?
Yes, sir.
And it's true.
It's true.
And we're gonna submit this to the court as part of the proof in your testimony in this case, correct?
Yes, sir.
All right. Judge, we ask that you admit the will to probate as a muniment of title. And as I proposed like that prior hearing, I proposed in the order that you waive the affidavit of compliance because she's the only devisee.
So done. Thank you, Counselor.
Thank you.
Miss Martha, take care.
Yes, sir. Thank you.
Yes, ma'am. All right, back to the top. State of cause number 42. State of Lawrence Larry Jeffrey Barron.
Hey, Judge, this is Scott Rennick. I'm here on behalf of the estate. I think Mr. Anderson's there. I know he was waiting to get let in.
Okay.
And I think I'm the only lawyer who isn't a judge from what I've been hearing from everybody even talking to.
You may proceed, Counselor.
Judge, I'd ask the court to take judicial notice of the file. We had previously filed an application for temporary administration, which the court had granted in this matter. We are here asking for an extension of that application for temporary administration. The basis of which, Judge, is that, as you may recall, after Mr. Barron's death and also Miss Barron's passing, there was some chaos and uncertainty regarding the business dealings at Larry's trade days, just a lot of complication of that. And also there was a case pending in federal court regarding that issue. And Mr. Anderson, I know you're here today. Is what I've stated, is that correct?
Let me swear him in.
I'm sorry, Judge.
Raise your right hand, please.
Solemnly swear or affirm the testimony you're giving today is true and correct, so help you God.
Say it again. I see
might
your lips
be on
moving,
mute.
but we can't hear you. Are you muted? Yeah, you're muted, Mr. Anderson.
Can you hear me now, sir?
We can. Okay. You can put your hand down and you may proceed, Counselor.
Thank you, sir.
Mr. Anderson, you know we're here today to ask for an extension of the temporary administration, correct?
Yes, sir.
Okay. And as you may have heard me say to the court, when you came in, you kind of took the reins and were trying to figure out the finances with your father and with Mr. Barron and Ms. Barron's business, Larry Trade Old Days, right?
Yes, sir. It was complicated.
Yeah, and it's still very complicated. On top of that,
Yeah.
there is a case pending in federal court related to the underpayment of insurance proceeds related to a weather-related event out there, correct?
Yes, sir.
Okay. And you do feel that a lot of progress has been made, but we don't quite have all of the information that we need. Is that fair?
For the insurance case?
Well, for the organization of the business and the assets
Oh, yeah.
that may exist. Okay.
Yeah, we're in the pipeline getting it done. It's just complicated, and there are a number of things that have popped up.
And on
So-
top of this, sir, you also have had people, the property for itself, where the business is located, you've had people come forward interested to some degree about possibly purchasing the business and or the land. Is that fair?
Yes, sir. Yes, sir.
So we're not asking for the court for another 6 months. We're just asking the court if they would extend the temporary administration for 90 days for us to be able to gather the information and also for us to get the actual independent administration done so that we have a good knowledge of the actual assets in the estate. Is that fair?
Yes, sir.
Okay. Judge, that's where we're at. We think we can have everything done within the next 90 days to actually file the application for the independent administration. The other heirs, we have been in contact. We do not feel there's going to be any disruption to us being able to do that within the next 90 days.
Okay, and I assume it's the same testimony on 114, the state of Brenda Joyce Barron.
Yes, it would be, Judge.
Okay. So I am going to approve the 90-day extension on cause number 42 and also cause number 114.
And Judge, just so you understand, you know, we've come with this request previously. We will not come back for another request. We're going to have the independent administration filed before that 90 days expires.
Okay, that'd be great.
Thank you,
All right.
Judge.
Thank you. Good luck.
Thank you, sir.
Yes, sir. All right, cause number 77, the state of Jack Gregory Trigg. Mr. Benoit, good morning.
Good morning, Judge. How are you?
You may proceed.
Judge Brandon Benoit here on the estate of Jack Gregory Trigg. Mr. Trigg passed away on May 4th, 2025 in Harris County, Texas. At the time of his death, he had a fixed place of residence and domicile in Mont Belvieu, Chambers County, Texas. He died leaving a will that was dated February 17th, 2022. The original of that will has been filed with the court. Since the date of the execution of that will, Mr. Trigg was not married, had no other children born to or adopted by him. To the best of my knowledge, he did not revoke that will. That will is self-proven as provided for by the Estates Code. That will names his wife, Rebecca Robertson Trigg, to serve as independent executor without bond. Ms. Trigg is qualified and not disqualified to serve as executor. The will does not name any governmental agency, state organization, or charitable organization as a devotee. And so we'd ask that the will be admitted to probate, that Ms. Trigg be appointed as independent executor to serve without bond, and that appraisers be waived.
So done. Thank you, Counselor.
Thank you, Judge. Have a good day.
You too. All right, last but not least, cause number 80, the state of Lloyd Allen Newman.
Morning, Your Honor.
Good morning, ma'am. You may proceed.
Okay. Michelle, can you state your name for the court?
Michelle Terry.
Okay, and Lloyd Allen Newman was your husband, is that correct?
Yes.
And he passed away on May 3rd of 2017?
Yes.
And that was in Chambers County?
Yes.
And he was 50 years old at that time, correct?
Yes, ma'am.
And Chambers was his fixed place of residence at the time of his death, correct?
Yes.
4 years has lapsed since he died, and you were unaware that you had to probate the will, correct?
Yes.
So you're not in default for failing to do it for any fraudulent reason, correct?
No.
And the court has been used since he was domiciled there in Chambers County, correct?
Yes.
And he did own property at the 4810 Legends Bay Drive in Baytown, correct?
Yes.
And that is valued at over 75,000, correct?
Yes.
And he did not receive any Medicaid benefits after March 1st of 2005, is that correct?
Yes.
And we filed a MERP certificate to prove that, correct?
Yes.
Okay, and he left a valid will dated October 5th of 2010. Does that look like his will right here?
Yes.
And we filed the original with the court, correct?
Yes.
Okay, the will was self-proved as required by law since there was 2 witnesses, and it was done in front of a notary, correct?
Yes.
Okay. And the will does name you as the executor, is that correct?
Yes.
And there was no children born or adopted after the creation of the will,
No.
and no marriage was dissolved after the creation of the will.
No.
And as far as it goes, you're the only one listed as a beneficiary and under the will, but there are 2 additional children, is that correct?
Yes.
Zachary and Christopher?
Yes.
Okay. And Christopher has passed away, but Zachary did sign a waiver proving that he received a copy of the will. Is that correct?
Yes.
Okay. And there's no state or government agency named as an advisee under the will. Is that correct?
Yes.
And there's no unpaid debts or anything that you're aware of that the estate owes. Is that correct?
No. Yeah, there's none.
Okay. Your Honor, we would ask that you admit the will as minimum title only. And there is also, she's the only beneficiary, ask for a waiver of the affidavit of fulfillment of terms.
So done. Thank you, Counselor.
Thank you, Your Honor.
All right.
Thank you. Is she able to come by and get the order and certified copy today? She's trying to do a closing.
Christy's in here. I'll let her answer that.
Okay, thank you, Your Honor.
Once it's over, once court's over.
Christy said she'll reach out to you once court's over.
Perfect. Thank you so much.
Thank you. Have a good day.